rise.
Thank you. Please be seated. This is an action entitled State of Ohio Plaintiff versus George Wagner III, case number 2018-0157, today is September 16, 2021. We're here for a pretrial and hearing on motions. Defendant is present in court today. Attorneys Mark Collins and Thomas Hayes, the court attorneys represent Mr. Wagner, and also Emily Enstead, attorney who's Hayes, is also present. Representing the state of Ohio is Rob Young, prosecuting attorney. We have Special Assistant Prosecuting Attorney Angela Kenneth and Special Assistant Prosecuting Attorney Andy Wilson, and Ryan Scheider is here, Special Agent with the Ohio Bureau of Criminal Identification and Investigation. Mr. Wagner, are you present in civilian clothing without restraints? Are you satisfied with the access that you're having with your attorneys here representing? Yeah. Are you satisfied with the services they're providing in your representation in this case? Now, you may talk with your attorneys before answering this if you want to. If you have any complaints about anything that you want to express,
no, not this time.
You can sit down. Let me just ask counsel: Are you is counsel satisfied with the access being provided to Mr. Wagner?
Yes, Your Honor. We are, and it's my understanding that Butler County increase our contact as well, because for a period of time it was down and very difficult to hear, and my understanding is that's being corrected.
Thank you. And we're scheduled to have some hearings today on several defense motions. I think most compelling, I guess, would be there was discussion about having a Daubert hearing, or actually a series of Daubert hearings concerning ballistics and concerning shoe print evidence. That was defendant's motions 42 and 43. It was also discussed having the defense file specific objections to some of the other acts evidence pursuant to rule submitted by the state pursuant to Rule 404B. That was defendant's motion 49. And there may have been some other, there were some other motions that had been withdrawn, and some of the material requested had been provided. It's the court's understanding that since that hearing that we were last year on April 5, I believe the date was, that the defense has filed 2 additional motions. We have motion number 50, which is the defendant's motion to compel the prosecution to provide any written and recorded statements from the co-defendant and evidence derived from the statements. I'll let the attorneys address that here in just a minute, where we stand with respect to that motion. And then we had defense motion number 51, defendant's motion for specific performance of the prosecution in dismissing the murder specifications against defendant George Wagner III. It's the court's understanding from discussions in chambers with attorneys from both sides that the defense wishes to argue today motion 51, and you may have something to say also about motion 50, but to the extent that any of the other motions remain pending, that we would go back and argue those, at least we set a date where those may be argued as November 17th at 1:30.
Yes, Your Honor. And please, court, I think the court has very well restated what occurred prior. Since then, Your Honor, since Jake's plea and now Angela Wagner's plea, we would withdraw motion number 50. The government was kind enough to hand us both of their proffers today, so we will go through those, and we appreciate that, so we will withdraw that motion. We would like you to hold in advance 42, 43, and 49, the ones that you referenced. only because the dynamics and the potential procedures of a trial of this nature have changed a bit, and depending on the Daubert hearing might not be needed and things of that nature in terms of trial strategy. But we will let the court know as soon as we're able to get through the information, and we would ask that you hold those in advance, and we would just like to do a brief argument on our motion number 51 for specific performance.
All right, thank you. Does the state have anything further to say before we begin argument on number 51?
No, Your Honor.
Thank you. Your Honor, to be brief, our motion, specific performance, when Jake Wagner entered the court back on, I believe it was April 22nd, part of the defendant's agreement on that was that the death specifications would be dismissed against the co-defendant. This motion is to facilitate and receive an order to have that death specifications dismissed. Billy Wagner is a third-party beneficiary of that. On page 2 of our motion, he certainly has standing. Defendant's agreements are well respected in contract law in Ohio, and the test is he a beneficiary of that agreement? The sole purpose of that agreement, where Jake Wagner would receive multiple life sentences, was to remove the death specifications from the co-defendants. We're asking for specific performance to do that. In the agreement that the state entered with Jake Wagner, it specifically states that applies to co-defendants. Specifically, they would be returned to their respective positions prior to the execution of the agreement if Jake Wagner did not testify. That's indicative that, one, it would have to be removed prior to the commencement of a trial. It would become unwieldy. It would become prejudicial to start this case as a death penalty case, and then only after the subjectivity of how Jake Wagner proceeded at trial that the state would then remove the death specifications. We are asking the court to uphold that part of the agreement. It certainly is well respected in law in Ohio that Mr. Wagner would be a third-party beneficiary of that agreement, so therefore we are respecting that portion of the indictments to be dismissed.
Yes, Your Honor. The state is opposed to this motion 51 that has been filed by Mr. Wagner. Specifically, I think it is very clear, first of all, in the defendant's, in the plea that was reached between Jake Wagner and the state, specifically in the plea, it says, pursuant to the defendant's agreement, the state also agrees to dismiss the death specifications against each of the defendant's co-defendants based upon the defendants fulfilling his agreement to testify truthfully in each of their respective trials. So, Your Honor, clearly it was contemplated that first Jake would testify and then and only then would we dismiss death specifications unless the defendants, each respective remaining defendants, agreed to waive their double jeopardy and speedy trial just as Jake Wagner did regarding the specifications, and again, contingent upon his fulfilling that agreement. I would also note, Your Honor, that while third-party beneficiaries can demand performance, first of all, they're trying to impose their desire to on when the state upholds its performance. The state's performance is not due until Jake fully performs his agreement. But also, third-party beneficiaries do not enjoy their rights until their rights have vested. And specifically, in order to vest, they have to assent to the promise in the contract. So, in other words, they have to agree to what was negotiated, and then have a contract of their own in a manner that's requested by the parties. And again, I would say this is exactly what the state has been proposing all along, which is that they also waive double jeopardy and speedy trial as the specifications, and then and only then would the state be comfortable dismissing it pre-trial. Otherwise, we would have to wait until Jake Wagner fulfills his end of the agreement by testifying, at which time he would dismiss the specifications, and at which time they would have a cause of action.
Just briefly, Your Honor, I understand what Ms. Scott is saying. However, the Defendant's agreement is where our client's rights, the origination of the genesis are. And in that agreement, it specifically says, Your Honor, this applies to the defendants, meaning Jake Wagner, the co-defendants, as well as specifically they would also be returned to their respective positions prior to the execution of this agreement. What that means is, Your Honor, the state had predicted that they were going to dismiss something, okay? And then if Jake didn't do what he was supposed to, they would reimpose the death penalty specifications against him and our client. That's what's written in there. Had they written the death specs were only to be dismissed after Jake testified truthfully and to our desire or to our satisfaction, then we wouldn't have an argument. But that's not what's in there. You can't put in a condition precedent without the condition actually happening. So they put in this agreement where our client's rights come from that the death penalties will be dismissed, and then if something goes wrong, they'll be reimposed. Now, whether they can do that legally or not, that's not our issue. Our issue is his rights of benefit as a third-party beneficiary arise from the defendant's agreement that he signed. He signed an agreement to testify truthfully and to plead guilty. He's pled guilty and to testify. That's what he's agreed to, Your Honor. Therefore, his rights, he has standing, his rights are there, and nowhere in this defendant's agreement for Jake Wagner does it say that the death penalty specs will be dismissed only after he testifies. Everything in there, Your Honor, says the opposite. It says they're going to be basically dismissed ahead of time. So that's why we'd ask you for specific performance to dismiss those prior to a trial starting. The reason being, Your Honor, is I've never been in a death penalty case, Your Honor, where it started that, hey, I'm going to dismiss the death penalty specs once our people testify. Because that, to me, is setting it up for appellate issues and things like that, you know, from the higher courts. And in this situation, we would be wasting resources, time, doctors, psychologists, all those types of things, Your Honor, that normally are in a death penalty type case. And we would then add probably a good month to this potential trial if it was a death penalty versus a non-death penalty case. So we would ask for the specific performance under the motion that we filed, Your Honor.
What do we do with the language of the plea?
Well, but the plea, Your Honor, references the plea agreement. So that's why, I mean, I understand it, but the plea, it says as per the attached plea agreement. So the plea agreement applies to Jake, Your Honor. That's his, okay? And that's their representation. But once they said as per the plea agreement, that's where our client's third-party beneficiary rights arise. And it says in there that they will be dismissed. If something goes wrong, they will be reimposed. It's basically paragraph 11, Your Honor, that when you read paragraph 11, the second part that says if something goes amiss, they will be reimposed. So that's why the plea agreement applies to Jake. The defendant's agreement to plead guilty and to eventually testify truthfully, he's fulfilled that. Therefore, our client has a right to enforce that.
Further state.
Yeah, Your Honor. Again, the plea agreement states specifically that it's dependent upon him fulfilling that agreement. And the very first sentence in paragraph 11, which is the one they're referring you to, says the defendant agrees and understands that his completion of the terms of this agreement is to be determined by the state of Ohio. So again, Your Honor, I mean, at this point, quite honestly, we could change the terms of this contract with Jake, because this is a contract with Jake, not with their client. They get the benefit of that, but they don't have the right to change the terms or impose penalties if they don't exist.
Your Honor, once you give an intended benefit, like she just admitted that they did to our client, he is an intended beneficiary. He now has rights, and he is standing to enforce those rights. Exactly what Ms. Kenneth said is the problem with this plea agreement. It says up here, the defendant agrees and understands that the completion of terms of this is determined by the state of Ohio. So he could testify, and if it's not to their satisfaction, Your Honor, they can undo it and go from there. But still, right now, as the defendant agreements take place, our client has a vested, intended beneficiary, because the reason Jake Wagner pled guilty, Your Honor, and it was here in open court, was so that the death penalty specifications were dismissed against my client, his mother, and his brother. That needs to be enforced before the trial starts, Your Honor. That's our position.
Considering the language of this, of the agreement with Jacob Wagner, state agreement with Jacob Wagner, including the language of the plea, which is decided by the state's attorneys, the court will deny this motion. Is there anything further to come?
Not on behalf of the state, Your Honor.
I think, Your Honor, if I'm correct, we set another kind of pretrial for November the 17th at 1:30 p.m.
November 17th, 1:30, a pretrial and possibly motion hearings.
And we will contact the court about the motion hearings in advance and let the court know our intentions and the governor our intentions.
Thank you, Your Honor.
You know, and